a good refresher for us, especially with some recent law changes, so we can get it all wrapped up into one simple class. Let me go ahead and go through the housekeeping as I normally do. Again, my name is Alina Gilbert. I'll present today. And on your screen, the bulk of it should be my PowerPoint. So you should see the company policies picture. And the bottom right-hand corner is the presenter, which is me. Hi. And on the left, you're going to see a few icons. And specifically look at the one that looks like a little talk bubble. That is the chat icon, and this is where your questions go. So if you have questions as I'm going through this, please just type them in there and they'll come through. I am going to save all questions for the very end just to make sure we have enough time to get through all the materials. There's a lot to go through today. You will get a copy of the PowerPoint along with your CMCA certificate after the class, usually within 24, 48 hours. So if you don't see it in your email, please reach out to us and let us know. If you're having technical difficulties during the class, please reach out to our education coordinator, Sean Sanders. You can call him directly at 303-991-2076. You can email him at education@altitude.law, and hopefully he can help you if there's any technical issues on your end. This webinar is being recorded. It is going to go on our YouTube channel, as all our other webinars do. So if you find this scintillating and you want to keep watching it over and over and over again, then guess what? You can, because that's what you guys like to do, right? Watch the same video over and over and over again. All right. Let's get started. I'll make sure I think I covered everything I was supposed to cover. All right. So before we start talking about the actual policies, I think it's good to talk about what a policy is. You know, we use terms such as policies, resolutions, rules, guidelines. We have all these terms we use, and we use them interchangeably most of the time. And they really are each different, even though we don't typically make the distinction. A policy should be obviously a written instrument that sets forth some sort of a process or a protocol on how the association is going to do something. It is adopted by the board of directors by a majority board vote. There's not homeowner approval. Obviously, that's necessary for a policy. And it can't conflict with anything in your other governing documents, such as your declaration, bylaws, or articles of incorporation. Obviously, can't conflict with the law either. It's a separate document. Sometimes folks think that a policy is like something that's part of your bylaws or part of your declaration, and it's not. It's a completely separate legal document that the board adopts. And we have in Colorado 9 policies that are actually required by law, and that's CIWA, the Colorado Common Interest Ownership Act, which requires these 9 policies. It all started back in 2005, way back when I'm sure you guys have all heard of or experienced Senate Bill 100, which was the beginning of a reformation of CIWA. And it added this requirement for good governance policies. Started off with 7, but as you can see, we're up to 9 now. So who knows if there will be more. So let's talk about which policies are required first and what they need to have. And honestly, we could spend a much longer time on each of the policies individually, talking about what should and should not be in there. But because we're going to go through a lot of different policies, I'm just going to skim the surface. And if you have specific questions about what a policy needs to contain, either we can try to get it at the end of the class, or please feel free to reach out to me afterwards. But this is really an overview. So collection policy and enforcement policy, I put those first because I think They are the most important ones because almost all associations have collection issues and almost all associations have enforcement issues. So the collection policy, remember, it's a process, right? So it's the process of what an association does when it has homeowners who are not current in the payment of their assessments. Back in 2014, the law changed, Kiowa changed with respect to what needs to be contained in the collection policy and the process that needs to be followed. So for your communities, if you have a collection policy that was drafted prior to 2014 or late 2013, you probably need to consult with the association's legal counsel because it probably needs to be updated. In 2014, we had the requirement come in that every owner is entitled to at least one offer of a payment plan if they're delinquent. We had additional requirements coming in as far as what information needs to be contained in the collection demand letter and what other information needs to be attached to it. And so that was something that didn't exist before. We also had an addition here of the minimum dollar amount that a homeowner must be delinquent for an association to be able to foreclose, and what the board needs to do before it starts a foreclosure action. So FYI, minimum amount to foreclose is a delinquency of at least equal to at least 6 months or more of assessments. It doesn't mean you have to be 6 months delinquent, but it means the dollar amount has to at least equal 6 months of assessment. So it can include your late fees, you know, your interest, and that's the amount we're going to look at in total. There is a whole bunch of stuff we're going to add to the demand letter now, right? You got to tell them and all the things, these are all the things we can do to you if you don't pay. We got to give them the 30 days to pay or enter into a payment plan. The payment plan has to be at least 6 months and equal monthly payments. So there's a lot of stuff that your collection policy needs to contain ever since 2014. So take a look, make sure your policies are 2014 or later, and that they contain, you know, this language. Enforcement policy, another big one, because this was required back in the original Senate Bill 100 with you had to have an enforcement policy. There's certain information that needs to be in the enforcement policy. Specifically, you need to have your fine structure in there. You have to have the specific fines that are going to get imposed. You need to talk about the notice and hearing process, which again means no fine is imposed unless the homeowner is provided with notice of the violation and an opportunity to schedule a hearing to talk about it. So if you are sending letters out right now as a board or as a community manager, and your violation letters have something along the lines of, we received a complaint that your grass is too long. Your grass is too long, and therefore a $500 fine is being imposed against you. If you wish to contest this fine or tell the board your side of the story, you can schedule a hearing by calling this number. Can't do that because you've already slapped that fine onto their ledger. Can't do it. What you would have to do is just say, you may be in violation. This is what you may be in violation of. You have the right to schedule a hearing to tell your side of the story. If you either don't schedule a hearing or you schedule it and you don't show up, the board will make a decision as to whether or not you are in violation based on the information it has. And then we will notify you if a violation is found to exist because a fine of $500 is going to be imposed. So that's a big difference. Saying it's already been imposed versus, hey, we're going to make the decision at a hearing if you schedule one, or if you don't schedule one after the time that we've allotted you to schedule the hearing. The enforcement policy, obviously, also you want to talk about the whole enforcement process. Are we doing warning letters? Are we doing courtesy letters? Are we doing, is it a fine threat letter right off the bat? What are you going to do if someone is a perpetual violator? Like, I violated the covenants 3 times in the last 3 months. Does anything different come into play? When do we turn it over to legal? You know, that type of a thing. So it's the full gamut of what's going to happen if you are in violation of the covenants or the rules or our guidelines or whatever else. Okay. So that's another recommended policy. What else we got? All right, we got conflict of interest, which is a conflict of interest for directors. Okay, this isn't a conflict of interest for community managers. This is a conflict of interest for directors. Now, this gets folks confused quite often because anything that kind of smells bad is a lot of times viewed as a conflict of interest by folks. This isn't right. You shouldn't be doing this. That's a conflict. You know, you're on the board and your wife is chairing the architectural committee. That's not right. You have a conflict, right? We hear this all the time. However, the Nonprofit Act does define what a conflicting interest transaction is when it comes to directors. And the bottom line is it's got to involve some sort of monetary gain. All right. So for example, I'm a board member, I own a business, and I am submitting to the board a contract proposal to use my business. That's a conflict of interest. I may not own the business, but my son owns the business and I'm submitting. Still a conflict. So there really needs to be some sort of a monetary gain here with respect to, you know, a transaction for it to be conflicted. And the policy is also going to follow the process that the statute states, which is, you know, it's not automatically invalid. You can still have a conflicting interest transaction. It's just got to be disclosed, and a majority of disinterested directors have to approve it, or homeowners have to approve it. I've never seen anyone, you know, go down that route, to be honest with you. It's usually the board. But you should have a policy that talks about this. Now, unless you have your governing documents like your declaration or your bylaws that take it further, like, you know, conflicting interest transaction also includes, you know, a husband and wife sitting on the board and on a committee. We're not going to define that as a conflicting interest transaction. So most of the time, you're not going to see anything extra in your declaration or your bylaws about that, but you should check and make sure there isn't, because if there is, obviously you want to make sure that's included in your policy. Adoption / revision of policy. So it's a policy on adopting policies, revising policies, as well as rules, regulations, resolutions, guidelines, whatever. And it sounds kind of funny, you know, when you first say it's a policy on adopting policies, but nevertheless, it is a process that is utilized by an association when it goes through either adopting new policies, revising its rules, adopting new rules, things like that. And kind of the primary focus of it and the intent here was, how are the homeowners involved in this? Do they get notice of this? How do they get notice? And so sometimes if you look, you know, make sure you look at your policies for each of your communities, because sometimes we see these policies and they say, you know, we're going to send a draft to all the homeowners and give them 30 days to provide feedback. It doesn't mean we have to do what the homeowners say, but it's just this opportunity, and we have to wait 30 days for feedback before we can adopt it. Sometimes these policies will say, no, we're going to put this on a board meeting agenda, and homeowners can come to the board meeting and comment on it there. Okay, and that's their opportunity. But the policy does need to discuss kind of how we're going to allow homeowners to comment or present it or to see it. And there is I've heard a lot of folks say that, oh, doesn't Kiowa require a 30-day period for homeowners to comment? And no, it doesn't. Somehow that's a rumor that got around and everybody thought, you know, that that's what it was, and there really isn't anything like that. You just need to tell or to explain in the policy how that's going to happen, okay? Inspection of records. See the little double asterisks? When you see those, and there's a few policies where you'll see that, it means the law changed on this very recently, and by very recently I mean September of 2021. So the inspection of records policy, I mean that, first of all, take a look at the date on your policy. Make sure it's not prior to 2014 or late 2013, because at that time, the law had changed and became extremely specific with respect to inspection of records by homeowners and what can and cannot be inspected, the timeline, what associations could and could not do. So it became very specific. There's a list of records that is an exclusive list of records that homeowners are entitled to. Then after that, there's two lists of exceptions. One is things that the association may withhold, and the others are things that the association must withhold. So that really changed the playing field with respect to inspection of records. So take a look at yours. If you're seeing that it's like from 2005 or 2006 when this policy originally became required, it's not going to comply with the law after 2014. So you are going to need to have it updated. Check with your attorneys on that. However, in September of last year, the legislature added two little things, two additional records that you have to allow to be inspected by homeowners. It's nothing new. I think it's already kind of stated in there, but it's almost like a restatement of, you know, what's already in there. It's kind of like fees that have to be paid to the management company anytime there's a transfer, things like that. And so those are things that have to be disclosed anyway, but now that information is formally needs to be available. And so a lot of associations adopted or updated, I should say, their inspection of records policies last year to make sure they added those two items. If you have not done that, you're not in violation of state law, so don't worry. You're not gonna, you know, nobody's gonna come after you, but you just need to be aware that there are two additional items that of records that are open to inspection, and you want to just be careful if you're not going to add it in that you know what they are. All right, whew. Let's go on. We got more. All right, so here's the last four required policies. ADR stands for Alternative Dispute Resolution, which alternative to filing a lawsuit, right? It's an alternative to filing a lawsuit. How can we resolve our disputes without filing a lawsuit? It, you know, really pertains, mediation's a big form of ADR. Arbitration is a form of ADR, and people get those two confused. Arbitration is kind of like litigation, but it's in front of an arbiter. And this one individual really decides everything. And it is, you basically have to pay this person to be your arbiter. So it's a lot more expensive because you have to pay your attorneys and this arbiter person. And then you're basically giving up your right in most cases to file an appeal. So most attorneys will not recommend arbitration. Most of the time will say, no, do not commit yourself to arbitration. Mediation is a different thing. Mediation is unofficial. It's getting both parties in the room with a neutral third person who, you know, depending on how they work, but they can go in one room and say, you got a horrible case, you better settle this. They go in the other room saying, you have a horrible case, you better settle this, and hopefully something gets worked out. I've seen that tactic used. But anyway, so an ADR policy, most associations have one that just says, hey, we encourage mediation for disputes, you know, before filing a lawsuit. If a homeowner wants to have a mediation, we will agree to it. We will all, you know, something like that. It can be very short and sweet. It doesn't have to be very detailed, but you have to be careful because sometimes you see a set of covenants where the developer put in this horrible language about here's, you know, no lawsuit may be filed. Any types of conflicts shall be resolved as follows. And there's like this really horrible process in there. If you've got one of those documents, you're going to have to basically follow what's in there. And then your ADR policy can just say refer to Article X, Section 2 of the Declaration. Reserve studies. So a reserve study policy, this is interesting. Because it started off in the legislation as there was a proposal that reserve studies become mandatory and all associations be required to get reserve studies. Okay, that's how it started off as a bill. And after it went through the legislative process, it ended up being a required policy about reserve studies. And what does the policy have to cover? It has to cover if you've had an initial reserve study done, if you haven't, when you're going to. If you have had it, how often are you going to update your reserve study? How are you going to update? Is it going to be a physical inspection? Is it going to be something else? Is it going to be done by the board, by an engineer? And what are you going to do to fund the reserve account? So the funny thing, sad but funny, is that there's nothing in Kiowa with respect to this that says you have to have a reserve study. But you have to have a policy about a reserve study. So it's almost implied that a community must have a reserve study. So if you have an association and the board's saying, we're not going to do a reserve study and we're going to put that in our reserve study policy, we're going to have one that says we're just not going to do it. My guess is if someone challenges it in court, it's probably not going to fly. Unless you have a community where there's truly nothing that's maintained by the association. You know, no streets, no parks, no monuments, nothing. In which case there's no need for a reserve study because we're not replacing anything in the future. The investment of reserves, though, that's a different policy. And sometimes, you know, because we have the word reserve in both, people get them confused. So investment of reserves addresses your reserve account. So it's your bank account. And sometimes associations have a pretty well-funded reserve account and they want to make money off their money. So they want to invest, they want to get some return on their investment, they want some interest, you know, and so they have an opportunity to invest those reserves. And this policy is supposed to talk about kind of how you're going to do that. Generally speaking, it needs to follow what's called the prudent investor rule, which essentially means you are not going to take huge risks. We are going to do everything we can not to lose money, and we shouldn't lose money. And so you're going to do safe investments. You're going to consult with an expert in the field who's going to make recommendations, and you're going to do that route. So basically, you're not just making investments to make investments. You're not doing anything overly risky, and you're consulting with an expert prior to doing anything. Okay, so that's what that policy is. And then, of course, last but never least is the conduct of meetings policy. And that is exactly what it sounds like. What is the conduct we expect of not just board members, but homeowners and anyone who's in attendance at a meeting, whether it's a board meeting or a homeowner meeting? What do we expect? You know, you don't talk until the chair recognizes you. You don't yell and scream, no swearing. I mean, whatever you want to put in there. This is also where a lot of times we see language along the lines of you can't record any meetings, right? You can't video record it, you can't audio record it. But basically, whatever type of, you know, policies you want to have in place as far as how people are expected to conduct themselves, regardless of which side of the table they're on, then this would be the place for it. This would also be the place where you would put what happens if they don't comply. You will be asked to leave, or we're going to adjourn the meeting, you know, whatever works. With COVID, right, over the last couple of years, I think we've all gotten really, really good at virtual meetings. And I would guess that a lot more than half of our meetings are virtual at this point. Probably even more than 70%, especially right now. And so for those communities that do a lot of virtual meetings, a lot of them have adopted, and this is not required, but it's a policy on virtual meetings. And what that policy does is it basically incorporates this conduct of meetings policy, but then it adds to it basically all the virtual components, of what are we going to put in the notice? How do we accept, proxies? How are we going to vote? That type of a thing. How do we do it when it's virtual? So if you manage or on the board for a community that has a lot of, virtual meetings, and you're kind of struggling and it's hard to be consistent as far as what you're doing from meeting to meeting, you could consider adopting a virtual meeting policy that will help kind of make sure it's the same process is followed every single time. Okay. So anyway, these are the required policies, all 9 of them. So if you look at the bottom in red, what if we don't have it? What if we don't have these policies? What if I don't have some of these policies? What happens? So a couple things. The collection and enforcement policies, those are, like I said, those are the biggies. If you don't have a collection policy, or you don't have a policy that actually complies with the current law, you are not able to enforce your lien rights in court, which means you're not going to be able really to collect or foreclose because you don't have the appropriate policy. So that's huge. It is huge. And there have been homeowners that absolutely look at that and they will bring it up as a defense if they can. So that's one big problem. If you don't have an enforcement policy or a proper enforcement policy, you can't go to court to enforce the violations. So you're not going to be able to sue someone to have to require them to comply because you don't have the enforcement policy. So those are 2 big consequences to be aware of. The other possible consequence is whether it's the collection policy or it's the reserve policy or the ADR policy. If you don't have one of these or more than one, you are in violation of state law. We've got a statute that says you got to have all 9 of these. If you don't have them, you're in violation. What does this mean? It means a homeowner hypothetically could sue an association on the basis that they're violating state law. And you're probably thinking, so big deal, let them sue the association. There's really nothing that in the statute that penalizes us, right? Well, that is true, other than the provision that says if anyone sues to enforce the terms of Kiowa or the terms of a declaration, they're entitled to legal fees if they win. That's a big problem. Even if the association gets sued, and then all of a sudden you're like, okay, fine, I'll just adopt the policy now, no harm, no foul. That doesn't mean that homeowner isn't going to still try and get his or her legal fees out of you, because they had to go through all these steps and pay an attorney to file this action in order to get the association to actually comply with the law. So that's the risk, is association gets sued, association loses, association has to pay legal fees to homeowner for whatever they spent, and that could be expensive. Okay, so I think kind of the end result here is just make sure you have all 9 policies, and if you don't, call the association's legal counsel and get it taken care of. It's a fairly easy thing to fix. All right. Okay, let's take a comedic break here before we go to policies that are recommended. This is funny, and I always think, every joke has a grain of truth to it, so I wonder. Just saying. All right, let's talk about what's recommended. Flags and signs. See the double asterisk? Okay, so that is also legislation from last year that significantly changed Colorado law with respect to this issue. So let me go back in time first and tell you that, again, with Senate Bill 100 and all that, Kiowa was severely amended. And one of the things that was added was HOAs. You cannot prohibit homeowners from flying the United States flag or a military flag. And you cannot prohibit homeowners from putting up political signs, 7 days or 45 days before to 7 days after the ballot, and they can have one sign per ballot issue. Remember that? Okay. Well, the very important thing to take out of this is that is gone. Okay. So I know a lot of people still want to regulate the US flag and they want to regulate political signs. Those are gone. We don't have anything in the law that specifically protects these types of signs and flags anymore. What we have is something much broader. What we have is a statute that says, hey, associations, you cannot regulate flags or signs based on their content. Okay, so you don't get to look at the flag and say, oh, this is a US flag, that's okay to fly. But this flag, no, with your high school football team, no, that's not okay to fly. They get to fly. You don't have any say in what the flag says. The only exception to that is commercial messaging, right? What's commercial messaging? Well, it comes from the word commerce. It's messaging that's intended to, make money for someone, buy something, sell something. And in our context, what does that really include? For our purposes, for rent, for sale signs for homes, open house signs, garage sale signs, and I'm seeing a lot of those, little security system signs that people put. So those would be considered commercial in our world, and that you can prohibit them if you want because they're not protected by this. Although what I'm seeing is most communities are allowing at least for sale and for rent signs, in the community. It would be kind of, I don't know how it would fly if a community said, yeah, you have a yard, but you can't put a for sale sign up there. I think that might be a little bit dangerous as far as the response you would get on that. So again, we cannot regulate content. So imagine this, and I like to take things to the extreme, but I think it kind of it demonstrates the point. You get a call from a homeowner and they say, my neighbor's flying a flag with a swastika on it. And I'm Jewish and I am deeply offended and you need to make them take it down. Now, before, maybe that was something we could do because it was offensive, and maybe we have some language in our decks that talks about you can't have anything offensive or whatever. But now the response is, I hear ya, there's nothing we can do about it based on the content. This is not, all speech essentially is now protected for homeowners. So whatever they want to put, no matter how offensive, as long as it's not a sign that's commercial, we can't tell them they can't put it up because of what's in the sign. So what can we do now? Well, we can control the number. We can control the number of signs and the number of flags. We have to allow at least one sign and one flag. So it's one of each, not one or the other. You've got to allow at least one. But you don't have to allow more. So the association can say we're only going to allow one sign and one flag per home. You can do that. You can regulate the size of the signs and the flags. You do have to allow flag poles, but you can regulate the size of those as well. You can have other rules that are not content-based. They're content neutral. For example, flags have to be and signs have to be well maintained, can't be frayed or ripped, can't illuminate the signs, no flashing signs. I've seen all sorts of things. Your sign has to be professionally manufactured and lettered. Same thing with the flag. So you can do things like that, right? That talk about the maintenance. Location is, you can regulate location, but there's certain places we have to allow certain things. In a condominium community, where your balconies are limited common elements, right? And we don't necessarily want people flying flags and signs on their balconies. So for signs, we can limit it to being inside the condominium unit and in the windows. For flags, inside the condominium unit, in the windows, and on balconies. We have to allow people to fly a flag on their balcony. Okay, so that's something we would have to do under the statute. But we can say no more than one. So at any rate, you see where I'm going with this. Now, a lot of you have adopted, your flags and sign policies, which is good. A lot of you have not. So for those of you who have not adopted that, you need to be aware that without a policy on it or without something in your declaration on it that doesn't conflict with the law, you're not going to be able to regulate it. So for example, if you don't have anything in your declaration and you don't have a policy, a homeowner can fly 5 flags. There's nothing you can do about it because you don't have anything, excuse me, limiting the number of flags. Keep in mind, the statute doesn't limit a homeowner's right. It limits the association's right to control. And if you're not taking advantage of it and you're not actually imposing the controls that you're allowed to impose, there are none. So people can fly all the flags and signs they want. So keep that in mind and don't think that, oh, I don't need to adopt one because the law is governing this. It's only governing what you can do as an HOA. It's not telling the homeowners that they can't fly more than 2 flags or 5 signs or whatever. Okay, so that's important to understand. Xeriscaping's another one. Again, what happened last year was xeriscaping has always been protected. You can't, prohibit it, but now we've added something, and that something is can't prohibit artificial turf in the backyards. Okay, backyards only, you can prohibit it in the front. What about the side yards? That's kind of that gray area. I think the rule of thumb is if you have wing fences, you can prohibit it in front of the wing fences where, people would see it, but not behind the wing fences. But we don't know for sure. There's not any case law on it. It's brand new. The other thing with artificial turf to remember is that even though you can prohibit it in the front, you have to allow it in the back, and you can't necessarily limit how much of the backyard is artificial turf. So I was just actually reviewing some rules for an association, and they had one that said no more than 50% of the rear yard may contain artificial turf. Well, they can't do that. The statute doesn't allow us to regulate how much of the rear yard is artificial turf. What they could do instead is say, the exterior perimeter of the yard, or the perimeter, whatever, 12 inches of the yard must be framed in stone or whatever, wood chips. And then the rest of it we'd have to allow to be artificial turf. But we can't say that you can't have more than 50% of your rear yard be artificial turf. Hopefully that makes sense. And again, xeriscaping does not mean homeowners get to put all rocks or all wood chips in their yards. It means they are installing drought-tolerant materials and vegetation. So certainly with your xeriscaping policies, if you have any, or your requirements, you can require drought-tolerant vegetation as part of the xeriscaping, especially in the front yards. You can definitely say, like 70% of the front yard must be covered in drought-tolerant vegetation. So it is so it's not all rocks. All right, let's move on. Okay. The retention and destruction of records. I think this is another important one, and we don't talk about it enough. But essentially, we have a inspection of records policy. We have to have that. But now, if you have some internal process that you use with respect to keeping those association records and destroying those records, you want to be careful. If it's not spelled out in writing in a policy somewhere, you are going to get accused at some point of, tampering with evidence. You deleted this because you knew I, as a homeowner, was going to look at it, and you're trying to hide something. It's certainly a lot easier to say we deleted these documents in accordance with our retention and destruction of documents policy. Here's a copy of it. By the way, it's also on the website. And so in that sense, it's a much safer place to be. So if someone does accuse you of purposely deleting something that, you know, would prove the association's guilt in something, you would have that. The other thing is there are some statutory requirements as far as how long certain records must be kept. That could be a changing thing, but right now we have some very specific timelines in Kiowa as well as other statutes with respect to keeping certain records. And if you don't have a retention and destruction of records policy, you may not know what those are. So in a way, it's also a method to keep you informed as to how long you as a community manager, or you as a board member, how long you need to keep something for, like what the minimum time frame is. So for that reason, I think it's a very useful policy. I encourage associations to adopt these because I think they can be very, very helpful. Architectural guidelines. Again, this is exactly what it sounds like, and I suspect a lot of you have these. It's the standards of if you're making an exterior change to your home, here's what we are looking at. Here's what we're looking for. Here's what you need to do. If you're putting a shed in your backyard, here's your color options. We expect, you know, the style must match the style of the home. The building materials must be X. You need to put it in the least conspicuous location, right? So all sorts of things about any kind of exterior modifications or improvements to a home. And it doesn't really matter if it's a townhome or if it's a single family home. If you're allowing people to make, you know, exterior changes or improvements, you are best served by having a written architectural guidelines or rules. I really don't care what you want to call it, that at least narrows down the criteria and what is acceptable and more importantly, what isn't acceptable. Because if you turn down an architectural request, the homeowner's always asking, well, where does it say that we can't do this? Where does it say that we can't do that? So the more we can have in writing to point to and say, here, it says it right here, the better off we are. And legally, you're in a much stronger position to either enforce or to defend. Okay? So it's important, if you don't currently have architectural guidelines, you know, think about it, whether that's something your community could use. If you're a condominium community, obviously you probably don't need them because all the exterior modifications are done by the association. But if you're a community with people who own their homes, they own their lots, and they can do things there, I think the more specificity you can provide to them with your rules and guidelines, the better off the association will be in the long run. OTTARD, a very unfortunate acronym, wouldn't you agree? What does it stand for? Over-the-air reception devices. So it's satellite dishes, but it's also antenna and other types of over-the-air reception devices for communication signals. This one is a hard pill to swallow for lots of communities, but especially townhome communities. Townhome communities where the association is responsible for maintaining and repairing the building exteriors, but the homeowners legally own all of that. And what OTTARD says, and that is federal, it's FCC, OTTARD says is you can't have any rules or policies or covenants that, first of all, prohibit a homeowner from putting a dish or device on property that they own or have exclusive right to use. And you can't have any rules or policies that increase the cost of either installation or use, or that delay installation, or that makes the reception worse, basically. Okay, if it impacts the signal negatively, you can't do it. What does that really mean? It really means that unless you're a condominium community, and by condominium, I mean a legal condominium community with airspace units, I don't mean townhomes where the association maintains the exterior. You're not going to be able to control a whole heck of a lot when it comes to the dishes. So first of all, no prior written approval can be required. A lot of associations put that in their rules, and it makes me cringe because that is a violation of the FCC law, and that you could be subject to severe penalties. So if you have that in any of your rules and you are either a single family community or a townhome or a paired home, if you're not a condominium community, take it out, okay? What you can do is you can require notification after the fact, because that won't delay their installation. So you can require, like within 7 days of installation of a satellite dish, you must provide written notification to the association indicating where and when it was installed. Why? Well, it's good to have a record of these things so we know who they belong to and who installed it there. So if there's a problem, we know who we can go after. What else can you do? Well, you cannot, for example, require that a professional satellite dish installer install a satellite dish. Why? Because that's an additional expense. Now, hopefully most people are using professional installation people to do this, but we can't require it. You can't require them to put it in a specific location if that location impacts the signal. So here's what you can do. You can have a policy and it can say, ideally, we want you to put your satellite dishes here. However, if you can't get an acceptable signal, that our next preferential location is here. After that, our next preferential location is here. So ultimately, you're not really going to be able to do anything, but most folks, I think, try to comply with the policy. So if you give them at least a pecking order of where you'd like to see the dishes, hopefully most people kind of put them there. You can do that. Your policy can also say that if you damage, the exterior of your unit or a common area or whatever while you're installing, you are responsible for the damage. Okay. If you void any roof warranties because you installed your dish on the roof you just replaced, guess what? You're going to be responsible for that extra cost. Those are all things we can do because those do not increase the cost of installing the dish or using the dish. That's just a cost to maintain the building, which was there before. You can try to say, dishes, should try to be blended with the residents or whatever you think is appropriate for aesthetics. You can require, that there not be any loose wires anywhere and things like that. However, for the most part, non-condominium communities do have a hard time, and there's very little they can control. Okay. Again, we could talk about this all day, but we're getting kind of short on time, so I'm just going to move on. Submission of insurance claims and insurance deductibles. Typically, both of these are combined into one policy. I don't know that I would recommend having a submission of insurance claims policy without talking about a deductible, to be honest with you. And if you are interested in insurance deductibles, in February, the webinar I'm doing, I think it's the 15th, I'm going to do one on insurance deductibles, and that's all we're going to talk about as to figuring out how to allocate insurance deductibles. So it's a whole class worth of information. So I'm not going to go into detail today, but again, if you have questions and you want to know about the deductibles, please sign up for the February 15th webinar, and we're going to go into a lot of detail there. But insurance deductibles, insurance submission claims, this is messy, right? You got homeowners saying you need to submit a claim, and you're saying, no, we don't need to submit a claim. And when do we submit a claim? And what if it was the homeowner's fault? What if the homeowner was negligent? Why would we have to submit a claim in that case? And, that sort of thing. So this policy or these policies really would address when an association submits a claim and then who pays the deductible, because there's quite a few things that come into play when we try to figure out who has a deductible responsibility. Just keep this in mind. See, it says pre versus post Kiowa communities. If you are managing or on the board of a community created after July 1, 1992, then all of the provisions in Kiowa that talk about insurance apply to you. And there is language in there that implies that unless an association has a deductible policy that says something different, deductibles are paid by the association for any claims submitted to its policy. So be very careful. Now, there's an exception if someone was negligent and caused the damage, but anything like, acts of God or any other non-negligence-based claims, if you don't have a deductible policy saying, hey, you have to pay the deductible if you benefited from the work or if you have the maintenance responsibility. Kiowa implies that it is the association that has to pay. So that's a problem. If you don't have this policy post 92, talk to your attorney. If you're pre-Kiowa, so before July 1, 1992, these provisions don't apply to you because you were created before the statute, but that doesn't mean someone isn't going to try and argue that the deductible needs to be paid by the association because it's the association's policy. I would also encourage you, and I know I've talked to a few insurance brokers, they're all encouraging their associations to adopt these deductible policies because there's more and more pushback now from homeowners and from the homeowners insurance companies with respect to the deductible amounts. They want the association to cover them. So this is something that can help protect you, and there's no reason not to do it. I would highly encourage everyone to make sure their communities have these. Okay. Renewable energy generation devices, energy efficiency measures. So real quick, the renewable energy generation devices is really two things, solar panels and wind generators. Can't prohibit them. What we had before, the double asterisk is what we got last year. What we had before last year was a provision that said rules are not going to be enforceable if they significantly increase the cost or significantly decrease the generation of the energy. And nobody knew what significantly meant, so we're all guessing. Well, so last year, again in September, became effective. Significantly is now defined as 10%. So if you have rules that increase cost by more than 10% or decrease efficiency by more than 10%, they're not enforceable. So a lot of associations are adopting or they're actually updating their solar panel policies, if you have one, to clarify that. Energy efficiency measures, again, that's your retractable clotheslines, awnings, shade structures, evaporative coolers. It's a pretty tight list of what it includes. And I think this is probably my least recommended policies because I think you can address all of this in rules and regulations. I don't know that you need a specific policy, but these are all protected and they can't be banned regardless of anything that's in the declaration. So you could have a policy on it, but you could address it in your rules if you want. Phew, goodness. Okay, this means, I'll let you read it, we are ready for questions. So I am going to, while you're reading that, click to the questions. All right. Has everyone read it? Are you laughing? Maybe, possibly. All right, here's another one. Okay, I'm going to go ahead now, go through the questions and get through as many of them as I possibly can. Can you use policies to update outdated sections of other governing documents? Your comment on no conflict would say no. Exactly right. You cannot use policies to update other governing documents. That can only be done through an amendment to those documents, which most of the time require homeowner approval. What are the 2 records that were added in 2021 inspection of records policy? Like I said, they were the any fees or costs that may be charged by the management company when a unit transfers. And there was one other one, I apologize, it's like it slipped my mind. But it's if you want to email me later, I can give that to you, or it's on our website too. So I apologize, I can't remember the second one. In a simple HOA, not condos, and only have fences and irrigation to reserve for, can the board do their own reserve study? I mean, there's nothing that says a board cannot do its own reserve study. However, you kind of have to look at the possibilities of everything that could go wrong. And what could go wrong is, well, are the board's engineers, because that's who really does reserve studies, are they experts in this particular area? Do they know what the life expectancy is of an irrigation pipe? Probably not. And so how good can this reserve study be? And is the board breaching its fiduciary duty by not getting an actual reserve study from an engineer so that the association can be adequately funded to deal with these problems down the road? I think it's a bit of a gamble myself. I don't know that I would recommend the board doing it unless you have some experts on the board. Can you explain why it is frequently in the conduct of meetings policy, no recording? Many people have wanted to start recording meetings. It's in there usually because anything and everything can be taken out of context when you're recording something. And every person, no matter who they are, can get to the point where they're going to say something at a meeting that they wish they hadn't said. And really, do you want a recording of that? Homeowners in the past who have recorded meetings, they can send out copies of the recordings, but you cut and paste things, and it sounds like someone said something they didn't actually say. So it's basically a fear of abuse of that information if a homeowners or anyone really, it records the meetings. That's, I think, the main reason why most associations don't want to have their meetings recorded. It's just too easy to say something bad, and it's too easy, especially with social media, to get it out there for the whole world to see. I love that saying. All right, can a single family home allow the flagpoles attached to the home but restrict freestanding flagpoles? No, there's not a, the Kiowa does not distinguish between attached flagpoles and freestanding flagpoles. It says you must allow flagpoles. So I don't believe you can restrict and say only flagpoles attached. Some people don't even think they're flagpoles. Some people call them masts. And are they truly flagpoles, or do flagpoles have to be in the ground? I would not go there. I would not recommend going there. What are the consequences for the property management company if specific homeowners are excluded from certain emails that have been sent to the rest of the homeowners? I think if it's like a one-time oversight, I wouldn't give it too much thought. But if it's something that continues to happen, I mean, all homeowners have to be treated the same way, and you got to communicate the same with all homeowners. I mean, assuming it's a topic that impacts all homeowners. What's going to end up happening if there's some wrongdoing or anything is the homeowners are probably going to go after the association, and then the association is going to say, no, it's the management company's fault, go after the management company. I don't really know. I think there's a lot of things there, though, that I would, you'd need additional information as far as what the type of communication is, what it's about, how's the communication sent out. So I, don't take my comments on this to mean that a management company can never send communication to not all homeowners, because they can. It just depends on the circumstances. How many years does an HOA have to retain records? Do they have to be hard copy? So again, there's different time frames for different records. So there's no one like you have to retain all records for 10 years. There's nothing like that. Some records have to be retained permanently. Some have to be retained for a year, some 7 years. So it just really depends on the records. And as long as you retain them, and you can do it in an electronic format, as long as you're able to convert it to written material, as long as you can print it, it's fine to keep it in an electronic format, and I think most folks actually do. With satellite installations, does it mean covenants cannot require where it is located? How do the rules differ with paired home communities? So the covenants, again, if it's not a condominium community, the covenants cannot require where it is located if the homeowner cannot get an acceptable signal there, or if it's more expensive to put the dish up there. So that would not be enforceable. And let's see. Sorry, I'm looking at the. How do the rules differ in the paired homes? Well, most paired homes are still considered. Well, you have to look at your documents. Paired homes most of the time are not condominiums. So paired homes are going to be treated like single family homes and like townhomes. You just won't be able to control much of anything there. Is there, oh, if there is a retired PA that insists on developing a reserve study in order to save the HOA money, would he and or the board be held liable if he is mistaken in any way? Honestly, I don't, as long, I mean, if you're saying will he be liable for creating a reserve study, that's wrong. I think this retired PA would probably have liability for it. My recommendation would be to use someone who's active, who has a valid insurance policy in place, that hasn't stopped practicing, because things change quickly. And so I don't know that it's a good idea to have someone who's retired and lives in the community do it when they're not actively, doing it. All right, we are out of time, and I apologize. We're not going to get, there's a couple more that I'm not going to get to. Please feel free, here's my email address. Please feel free to just email me one-on-one, and I'll try to answer any questions I did not get to. And I'm really sorry, and these are all super, super good questions. So thanks, everyone. Hopefully I'll see you next month at the insurance deductible one.